3, 2, 1, start. In the light of scope of Order 7, Rule 11A of the CPC, we would now proceed to examine different submissions made on behalf of the appellant. The submission that the plaintiff was presented on December 26, 1978, whereas issues for determination were framed by the learned judge on July 21, 1981, and therefore the application filed by the respondent under Order 7, Rule 11A of the CPC on June 26, 1996 should not have been entertained at such a long distance of time, has no substance, As noted earlier, the provisions of Order 7, Rule 11A of the Code of Civil Procedure are mandatory in nature, It is the duty of the court to reject the plaint which does not disclose cause of action, If a plaint can be rejected at threshold of the proceedings, we do not see any reason as to why it cannot be rejected at any subsequent stage of the proceedings, Even if after framing of issues, the basic defect in the plaint persistence, namely, absence of cause of action, it is always open to the contesting defendant to insist that the plaint be rejected under Order 7, Rule 11 of the CPC, and the court would be acting within its jurisdiction in considering such a plea. Order 7, Rule 11 of the CPC does not place any restriction or limitation on the exercise of the court's power. It does not either expressly or by necessary implication provide that power under Order 7, Rule 11 of the CPC should be exercised at a particular stage only. In the view we are taking, we are fortified by the judgment of the Supreme Court rendered in the case of ITC Limited Supra, Therein, the suit was filed by the bank in the year 1985, In 1995, it was transferred to Debt Recovery Tribunal, and thereafter an application was filed by the appellant under the provision of Order 7, Rule 11 of the CPC for rejection of the plaint as not disclosing any cause of action against the appellant. The application filed by the appellant was rejected not only by the tribunal and appellant tribunal, but also by the High Court, When the matter reached before the Supreme Court in the year 1997, it was contended that the power under Order 7, Rule 11 of the CPC should be exercised after such a long lapse of time, more particularly when issues were framed, That plea has been negatived by the Supreme Court in following terms, We may stated that in the context of Order 7, Rule 11 of CPC, a contention that once issues have been framed, the matter has necessarily to go to trial has been clearly rejected by this court in Azhar Hussain vs. Rajiv Gandhi, SCC P324, as follows. The trial, record the evidence, and only after the trial is concluded that the powers under the Code of Civil Procedure for dealing appropriately with the defective petition which does not disclose cause of action should be exercised. Full stop. With respect to the learned counsel, it is an argument which is difficult to comprehend. Full stop. The whole purpose of conferment of such power is to ensure that a litigation which is meaningless and bound to prove abortive should not be permitted to occupy the time of the court. Full stop. Para. The above said judgment, which related to an election petition, is clearly applicable to suit also and was followed in Samar Singh vs. Kedarnath. Full stop. We therefore hold that the fact that issues have been framed in the suit cannot come in the way of consideration of this application filed by the appellant under Order 7, Rule 11, CPC. Full stop. In view of settled legal position, plea that powers under Order 7, Rule 11 of the CPC should not have been exercised after framing of issue cannot be upheld and is hereby rejected. Full stop.